right? And okay, and bear with me. I'll just put a message in the chat. Let's see, chat. Okay, hello. Okay, this and then note. Okay. Personal information. Okay. All right, I want to know, can people hear me or not? Somebody can maybe send a message in the chat about that. Like a simple yes or a thumbs up.
Yes.
Something. Okay, that's great. All right, so it is slightly past 6 p.m. and let me commence. My name is Mr. Max Chaudhary of Chaudhary Law Office. I have a Canadian immigration law firm in Toronto, Ontario, Canada. I've been a lawyer for 30 years, a bit more if you count the apprenticeship, if or whatever that may mean to you. And the purpose of the webinar today is to provide an opportunity for people to get general guidance about Canadian immigration legal issues. Keep in mind, as I've indicated in the chat, that this is being recorded and excerpts of this will be online. So although the purpose of this is to receive questions and provide general guidance, keep in mind that it's necessary that you anonymize the questions so that you maintain confidentiality for this purpose, because as I indicated, excerpts of this will end up online because that's the world we live in. That's how you get to know lawyers and other professionals, by seeing them do whatever they do. In the case of lawyers, what we do is we hear a fact situation, we review it in light of the relevant laws and policies, and then we advise a course of action or alternative course of action, depending on the circumstances. And that's sort of the sort of fundamental aspect of what we do, what most lawyers do in this situation. Other aspects include maybe being hired to respond on your behalf or to initiate an application on your behalf with the immigration department, or to respond to something very grave like investigation or deportation from the Canada Border Service Agency. So that gives sort of a sense of what lawyers do in general. And circling back to today, in some cases, I can answer the question as best as possible, but because some of these questions may require more background detail, you don't want to be in a position where you're revealing too much, and then you may want to get, appropriate, proper legal advice, perhaps from our firm, under the auspices of a formal consultation. But on the other hand, maybe the issue you have may not necessitate a personal consultation because it's a very general question. So use some discretion. And with that in mind, we have something like an hour left. And if we can commence this by having some questions in the chat, including follow-up questions, then I will review those questions in the chat, and then I will endeavor to answer those. And I may have another question for you, depending on the initial question you pose. There's not a huge amount of people here today, so that means there could be a back and forth of a bit more detail for the people who are here, barring, of course, late entry, which because sometimes people do that as well. So, with that in mind, uh, I want to ensure that there's every opportunity for you to pose a question. So please feel free to do so in the chat. The big concerns for many people, kind of never ending, includes delays in applications. And somebody did pose a question to me about that today, and I think they might be joining us, giving some specificity to their delayed application. A lot of these recent interactions we see are from a lot of people who are based in the United States, either US citizens or people with temporary status in the United States or no status in the United States. And they want to have some background about what their options are in terms of the Canadian immigration system. And so that means I may see some of these questions here as well. So with that in mind, I'll take a peek at the chat, and it says here, a policy-based question, the temporary public policy to facilitate permanent residence to certain foreign nationals affected by the conflict in Sudan with family in Canada. So as the poser of the question may know, there is a policy. I believe it allows 3,000 Sudanese, if they have an anchor relative, to have the relative be in Canada temporarily because of the conflict in Sudan, which commenced, I believe, April 2023 or so. And with that in mind, let me sort of dig a bit deeper into the question there, right? So there was a supervening fact in this situation. So the program opened, and then the main applicant got married. The main applicant was residing in Sudan when submitting the application. 3 months later, the principal applicant moved to another country and completed, it sounds like medical, and later the principal applicant was summoned to work and sent an email to an immigration office, a Canadian visa office, and indicating the inability to comply with the requirement for a medical examination. And then, so that is, it looks like from quite recent, from December 11th, 2024, it looks like there's a time frame up until February the 28th of this year. So, and then there's, it looks like, I'm just paraphrasing the substance of what they were requesting or asking clarification from in terms of the Canadian immigration application. And then it mentions a bit more context, such as method of transport for the purpose, I believe, of employment, which varies in this individual situation, the method of transport. And that described, it looks like the sort of travel itinerary was disclosed to the Canadian immigration authorities. And then it sounds like there was effectively a rationale or reasons for an extension of time to comply with a specific requirement by the Canadian Immigration Department. And as a consequence, based on that context, it is, does the principal applicant return to Sudan impact the eligibility to this program, namely durable solution? So one thing to keep in mind is durable solution is a specific concept related to outside of Canada refugee applicants. So the concern is that you could completely ruin the chances of immigrating to Canada as a protected person. For example, somebody who is a foreigner who's a beneficiary of a group of 5 sponsorship. And the part of that application is to determine whether there is what's called a durable solution. So can they simply remain in their current country of residence, which is invariably not the country of persecution, because they have a durable solution, namely they can live and work and almost live like a regular person. In the Sudanese case, if I recall, now it's not 100% clear if this is the Sudanese temporary policy or the group of five. I mean, maybe they insert that in. If this is, for example, a group of five refugee application, then this could trigger a set of questions by the Canadian visa officer asking about the nature of your tasks and duties in the other country you're temporarily in, and also include a demand for the nature of your status. Is it a temporary work permit? Does that work permit have to be renewed every 6 months or 12 months? Do you have substantive freedom of movement as compared to citizens of the country you're currently residing in? If you do, if you can freely work and things of that nature, then you might have a durable solution, and that could jeopardize the success of an outside of Canada refugee application. So that's something to keep in mind. Maybe there was some further detail which I missed.
Sorry, I missed.
Okay.
Yeah, I just dropped from the call. The question related to the public policy for the family is not group of five.
Mm-hmm.
Number one. Number two, when I read the policy, it stated that the supposed applicant, it doesn't supposed to be an unprotected person if he granted a land. It doesn't constitute if he's been designated as a refugee or a protected person.
Okay, so if
you clarify.
Okay, so it sounds like it's under the policy, basically, right, to temporarily be in Canada.
Correct.
Okay, so I'm going by memory, but that policy does say that if the time the hostilities broke out, you were in Sudan, that is the key factor. And then you obviously had to escape. This is the sort of scenario. So,
if I might ask something, sorry to interject here. Sure. The policy stated one of the eligibility criteria is to be in Sudan during the war when initiated. But after that, this is part of the eligibility, but it doesn't include in the guidance, the procedure guidance, or the policy itself. It doesn't include any justification or rationale to return to Sudan. Number one. Number two, it's not clear if somebody temporarily relocated and he have been coming back, what designation for that one. But bear in mind, there is a form have been signed by the anchor statutory form. That is the main applicant is supposed to be stated that he doesn't have any durable solution other than Canada or Sudan.
Mm-hmm.
In that, there is a form included on that application.
It's a declaration, I believe, yes.
Yes, correct. And on that declaration, he is supposed to state he doesn't have any durable solution
mm-hmm.
other than Canada or Sudan.
Mm-hmm. Correct. Oh, that's fine. So the concern about a durable solution, to be honest with you, because it's a temporary based application, they're probably not going to scrutinize it that much, and they may not sort of peek behind his declaration. But as a matter of safety, it sounds like, and if it looks like there's a reference to the global case management system notes that you acquired, and it said the officer responded, "I'm not satisfied on the balance of probabilities that a family relationship between the applicant and their dependent has been established." So there are certain family relationships that come within the ambit of this policy, like brother, sister, uncle, nephew, I forget the rest. So the alternative when you encounter this situation is the alternative to the main document. The main document is like birth certificate or family tree, which maybe connects parents and relatives to the anchor relative and to you. If you don't have a birth certificate or things of that nature, then it may necessitate an affidavit to be sworn to indicate the nature of the relationship and why you don't possess the typical documents, such as a birth certificate or other documentation to prove the family relationship. In some extreme cases,
sorry if I may inject again.
Sure. You can.
Just to clarify. Yeah, just to clarify. I think the officer mentioned this one, the family tie, to his principal applicant and his wife, because in the application we provide the officer with the date of birth certificate and everything.
Okay, so you have that already, right?
Yes, we did. But my assumption is based on the principal applicant and his wife, because the marriage happened before the application submitted, 2 months, and there is an age gap between the principal applicant and his wife, and there is no children.
So the age gap may have affected the officer's perception of the relationship, perhaps, right? So if you already have objective documentation that shows the relationship, like marriage certificate or birth certificate, in some cases that could be construed as valid on its face, because like an organically generated government document, like a birth certificate or marriage certificate, is deemed to be genuine. And they only have to impugn it or attack the genuineness if they see some inconsistency, like if they contact the agency that issued the document and they say, we have no record of this file number for this particular document. So things of that nature. So any alternative to buttress the proof of relationship, such as what I suggested earlier, maybe a sworn affidavit, would be helpful. If they're expressing concern about the document that's purportedly showing the relationship that's required, they're supposed to articulate that to you and issue what's called a procedural fairness letter. For example, that letter would say that we have concerns that the document that is supposed to show the relationship is not genuine, and we'll give you 30 days to respond. So that's a potential situation that may occur in this situation. So with that in mind, you can repose a related question, because we still have plenty of time. I'm just going to go to the next one for this. So somebody posed question. I hope they will pose more details after. And then I see another question here. My question is related to PR, permanent residency. I had foreign work experience, but I forgot to mention in the work permit application, as well as in my initial study permit application. What can be done now, and will that experience be added in an express entry application? So this is a fundamental aspect of many candidates for immigration who came through having initial experience or study permit endeavors in Canada. So, like everything, especially with the government, record keeping is quite diligent, unless you're talking about a record that's more than 30 years old. So of necessity, what that means is your historical applications, such as study permit to come to Canada, work permits, study permit extensions, all of those contain your personal history, which means personal history could encompass whether you worked or did not work, or volunteered, or studied, or things of that nature. And that's supposed to be comprehensive at the outset. In a situation where you filed for a study permit that entered Canada, studied for a year, filed another study permit extension, then graduated after 2 years, then filed a PGWP, for example, or post-graduation work permit, the immigration officer would deem, if any of those applications posed the question of your work and educational history, that's deemed relevant. Hopefully I said that right. So to the administration of the Immigration, Refugee, and Protection Act. If there's a situation where there was an omission in one of the previous applications, and you bring it to light, let's say when you're ready to file permanent residency, because, for example, You can get extra points if you have at least 1 year of foreign work experience under express entry. In theory, this could lead to a procedural fairness letter alleging that you composed a material misrepresentation in the past. So what do you do if you encounter this? Well, in some situations, you can try to argue the misrepresentation is a misrepresentation, but is not material to the administration of the act. Colloquially speaking, this isn't always the case, but sometimes this is synonymous with saying, well, if I disclose this in my study permit application, it would not have affected whether or not I would have been approved in the study permit application. That's not always the situation, but sometimes that is a valid defense when you omitted relevant information about your past, such as previous work experience or education. So, in short, the idea is to argue that you disclose this, but you have to make an argument that this is not material. On the other hand, if the officer deems it to be material, they could issue a 5-year ban from Canada. And the nature of the 5-year ban is that because it is 5 years and permanent residency is highly sensitive to age, as you can see from the express entry selection grid, that you, practically speaking, may not be able to come to Canada, at least not under express entry. There's other pathways, such as entrepreneur or family class, i.e. spouse, but that's something different, right? So that is a possible tentative course of action to deal with this, right? This potential material misrepresentation that you're contemplating if you want to accumulate the additional points that would derive from that extra 1 year or so of foreign work experience. So with that out of the way, I don't see any other questions, but please feel free to pose some, because we do have time, and this is for your benefit. And so I see something here. Okay, so for the language test, is the IELTS academic version rather than the general acceptable for the Federal Skilled Workers Program application. So for some reason, they only want the IELTS general, not the academic. Although I've heard in some instances, academic is useful for other purposes, such as maybe study permit applications, depending on maybe if you're seeking admission to a master's program in Canada. I've got a feeling if people do have the resources, we'll be seeing a lot more of these types of master's program applications. But focusing on your particular question, it's got to be the general, not the academic version of the IELTS test. And it doesn't matter if, as you probably read in the guide, doesn't matter if you came off of the Mayflower and have been a 30th generation American citizen. They still want an IELTS test, because it's an objective way to determine, without them having to do any work, because they farm it out to a third party, that you have a suitable degree of English language testing. So that's sort of the main aspect to keep in mind for this. So that was a kind of a straightforward one. So I want to know if there's any other questions, because we do see, oh, okay, here we see something here, right? So this might be related to the previous Sudan application. So that Sudan application related to the temporary public policy. And then in terms of more background, it said we submitted all the required documents, marriage certificate, birth certificate for both the anchor and applicant. And then the question, I believe, is that if that is the case, that means we will wait until the officer contacts us. In this situation, from what I recall, there was a notation in the file that there's some concern expressed. They are supposed to tell you the concern and give time. If it's something material to the outcome of the application and something you could not be reasonably be aware of, then they have to issue you a procedural fairness letter and give you 30 days or so for this. With that in mind, if I didn't answer that question, please repose with a bit more context, because I'll proceed To the other question which I see here, which is I completed my university studies May 2024 and am eligible to apply for a 3-year open work permit as I finished a 2-year program. I submitted my application online from within Canada, but I have yet to receive any response. I've made several inquiries through the IRCC website regarding my situation. Despite my multiple status check requests, I have only received standard responses that do not provide any meaningful updates. Is there anything else I can do? If I schedule an appointment with you, would you be able to review my application and assist me further? Or is it simply a matter of waiting at this point? So there's been a fluctuation in the processing time for work permits, because then we, as part of our job, we look at least the official published processing time. And if we look at the inside of Canada, they're saying 135 days, so about 4 months. So, as such as it is, that sort of published processing time is something of the kind of lens that we use to determine a kind of fulcrum or step to determine if this is an unreasonable delay. So, assuming for the moment that when you had filed your PGWP in May, that the processing time was similar or shorter, given the fact that that processing time has been exceeded by quite a few months, if we start from the premise that you submitted a complete application on a portal, which means you paid the fee, you filled out the virtual forms, then under the law, you've done everything you could for them to make a decision. The government has taken your money. You've given them the information they demand in their idiosyncratic forms. And presumably that information does have the hallmarks of a necessary PGWP, namely completion of studies, compliance with study permit, terms and conditions such as not working too many hours, for example, and being a full-time actively engaged student, etc. If you have all of those fundamentals for your PGWP, then given the fact that it has exceeded the processing time, you could consider a demand letter. One sort of contextual point, I'm going by memory, is that I believe you're allowed to be part-time, I think, in the last semester of your studies without being prejudiced or prevented from being issued the PGWP. But with everything in place, government forms, compliance with the law, the processing time has been exceeded. A formal demand letter is the logical step. A demand letter cites the relevant federal court case. I think it's the Federal Court of Appeal case of Apotex, unless there's a new case. That sets out the criteria for mandamus, saying, this is a formal demand. Please make a decision within 21 days. Here are the points in the Apotex case as applied to my case. And by the way, I'm prejudiced because maybe you might be prejudiced because you can't work and you're in limbo. Then if you have all those ingredients, you submit the demand letter. That might work. If it does not work, then you take that demand letter and then you go to the federal court and you say, I submitted a formal demand because everything that was required to be done by me for the PGWP was done. And I asked them in a formal demand to make a decision. And I expressed some prejudice to my situation in Canada. Then you go to federal court and they would agree. Sounds like they would agree. For the moment, let's assume they would agree that this was an unreasonable delay and you were prejudiced. And they would order the immigration department to make a decision on your work permit, perhaps within 30 days. Excuse me. So I hope that answers the delay question. If not, pose a related question because we still have time. So a further question, excuse me. related to an ongoing PGWP is whether there's a possibility that a post-graduation work permit can be extended if one is currently working. So in the grand scheme of things, every applicant only gets one PGWP in their life. There was an exception during COVID where they had these blanket exceptions because people couldn't work. So the benefit of a work permit was hardly there because there was no employment during 2020 and 2021. So aside from those sort of freak situations where they did extend PGWPs, the norm is you only get the one PGWP tied to the amount of studies you did, maxed out at 3 years. However, in somewhat rare circumstances, I don't want to say it's super easy, but in some circumstances, you can try to extend a PGWP with what's called a TRP plus work permit extension. TRP is temporary resident permit application, which is meant to correct minor violations or some serious violations under the Immigration Refugee Protection Act and regulations. But then you have to express the need for you to work longer than anticipated. It has to be a pressing need. And also you have to prove that the risk to the integrity of the immigration system will not be compromised. What does that mean? Well, the integrity of the immigration system, at least my interpretation, is that the rules are there for a purpose and they can't simply bend them or eliminate them willy-nilly. There has to be a pressing reason for this. That's why I emphasize that the norm is that if you have a 2-year graduation from a publicly funded school, you get a 3-year work permit, generally speaking. And from the point of view of the Immigration Department, that's plenty of time. Well, at least it was plenty of time before July 2022 to get sufficient work experience and enough points. It's a different scenario now. So that option of extending a PGWP is really in rare circumstances where you're affected in a very adverse way. So that's why we don't want to say it's easy, but we've encountered it in the past. And if there is a pressing enough reason, then the officer could extend that work permit. Again, I hope that's answered the substance of it. If not, repose something related. I see another, I think, looks like a PGWP question. This one says, I'm on my PGWP until October 2026. I started a business in 2023, a startup. And this year there'll be $100K in return on investment. So can I apply as an entrepreneur? So the entrepreneur categories, I say categories plural because they've been farmed out to the provinces. So every province has their own entrepreneur program. And I'm paraphrasing because there's 10 provinces and 2 territories. So there's some minor differences from province to province for the entrepreneur program. But for example, if we look at the defunct Ontario one, it's paused. Essentially, if you put in, I believe it's 250,000 in a business outside of the Greater Toronto area and have a net worth of, I believe, 600,000, then you can put in an expression of interest with the provincial authorities, not the federal ones. That expression of interest would consist of a language test and a business plan, and your business would have to be avoiding those non-qualifying occupations like passive investments or recycling or scrap metal. And there's a list of these exceptions to the requirements of the business. And then the business plan would hopefully show that you will create maybe 2 jobs. And based on your language test, which doesn't have to be that high, plus that business plan, they say, oh, we like this business plan. It's going to set up or buy a business in a small town outside of the Greater Toronto area with a promise to create 2 jobs. And the business plan has projections showing it will make money after 2 years. So then they would issue a certificate to you to allow you to file for a work permit. And then that work permit is restricted to that business endeavor that you are proposing would form the basis for your permanent residency. And then you would be subject to periodic reports to the provincial authorities about the progress of your business over the course of perhaps 18 months. And then after 18 months, if they see that the business performance plus the amount of jobs you promised to create have been maintained, they will issue you another certificate. And that certificate can be used to apply for permanent residency in Ontario. That's something of the norm for most of these provinces. Like I said, the Ontario Entrepreneur Program is paused. I'm just using that one because I know that one by memory. The other provinces are still available, and I think the money requirement, it could be less. For example, in a rural part of British Columbia, I think it's 100,000. But some caution has to be exercised because you have to be realistic about what kind of business can make money in a rural part of British Columbia. So that's sort of the overall broad brushstroke pathway for entrepreneur based on purchasing or establishing a business. With that in mind, let's see, there's a subsequent question. Okay, this looks like a policy question. With the IRCC plans of shrinking by almost half over the next 3 years, will that affect the applications and process? No, I didn't know it was half. I saw the headline, I think, the other day saying they're cutting 3,000 jobs from the immigration department on the heels of cutting a bunch of jobs from the Canada Revenue Agency. So I'm speculating a little bit, but we have these stakeholder meetings with immigration, and they're saying they're going to have a lot of automations and super portals, and things are going to be more automated, and they're kind of selling it as if they're not going to need as many people. But if you're interested, you can Google Chinook IRCC, which is sort of the internal government code name for the artificial intelligence that they're using. And you will find references to that all over the place. And it's been deployed to assist officers, this artificial intelligence platform, for temporary applications like visitor visas, study permits, maybe work permits as well. And at least at the start of 2021, when we discovered this, it was not working very well. There were patently unreasonable refusals being issued, necessitating resubmitting. And then sometimes when you resubmit in this Chinook artificial intelligence setting, they just simply refuse it in one day, just on the strength of an initial refusal, despite the fact that the initial refusal was wrong. This in turn necessitated a lot of federal court cases. So if you enjoy research, you will find the phrase Chinook in a lot of federal court cases. Many of them were overturning the refusal on the basis of an unreasonable decision. So maybe they will be able to deal with what they told us was 1 million pieces of email, I think, every 30 days somehow. But another stakeholder meeting for refugees, the Refugee Board, says that inside of Canada, refugee claims will take 48 months. So that's a huge amount of time. I mean, to be fair, a refugee hearing is not in person, but it's subject to a personal meeting online with a refugee member or judge. So those are labor intensive. So I can understand the 48-month delay. If you read the media, then you probably see the connection between people who've lost study permit status because it's expired or no longer have work permit status, and they end up making a refugee claim, and this is causing some damage to that phrase I mentioned, the integrity of the immigration system. The refugee system is not meant to be an alternative pathway. It's meant for people who have a risk to their life in their home country. So that's sort of my sort of pontificating, editorialized answer to that very brief question. If there's a follow-up, let me know. I'll just proceed, let's see, with So can your firm help with the extension of the PGWP process as per the question above? We do, but we always want to do a consultation because we want to get the exact relevant circumstances that characterize your immigration visa history and your future goals, and also the possibilities of what may befall you in your home country. And then based on getting all of those pieces of information, then we make a judgment call and we tell you what we think about, yeah, we think this is viable, or no, we do not. Because as every lawyer knows, or every lawyer should know, we can only do a case if we think there is some merit to it, unless the client says, I understand that the merit is low, but I still want to proceed. So that is the step we have to instruct you to take before we could give substantive legal advice about that, right? And then the other question is sort of similar. It says, can you help us with the demand letter process? And then, I should just let you know, I mean, instead of going to the website, you can also email my assistant email. You get the idea, right? So you could pose a potential consultation to that email, then they will let me know, and then you'd probably be seeing me in a personalized setting. That's when we look at documents. We ask you about compliance with immigration terms and conditions in the past, and talk about prejudice to you from the delay, that sort of thing, and then say, yes, we think this merits a demand letter, and maybe mandamus if the demand letter does not work. So that's sort of the idea, right? Sort of housekeeping question. What's the initial consultation? I believe it's 170 plus tax and admin fee in person, and then I think it's a bit higher if it's online, because we have to get your ID verified through a third party, and then so we have to pay a small amount of money for the remote consultations, because then we have a third party verify your ID card, that sort of thing. So it's a little bit more expensive for 30 minutes. I think with tax or something, it's $209 online, and like $192 or something if it's an in-person consultation for this. So with that in mind, down the road, something to consider. So with this, we still have some time. So I see another question sort of popping through here, right? So it says, I have an expressentry profile, but don't have enough points. So for this, the question is it worth a consultation? I think it may or may not, but what I can say, the pattern that has emerged in the past maybe 8 months, is that the programs that are kind of emerging are those where there is either a job offer or there is French-speaking points that are leading to easier pathway. So that's sort of the broad brush sort of assessment about how to configure your application. There's other pathways as well, but those depend on things like your financial wherewithal, right? The occupation that you worked under, because sometimes they have what are called targeted draws by the province, each province, and sometimes some of the advice ends up being looking at how much time you have left on your PGWP and seeing if you can try to find another kind of job. And then we look at that. So in some cases, there's merit to a consultation about this. But these changes that we propose, they may necessitate staying in Canada longer. They may necessitate maybe in some cases studying. So those things may be a longer term but more expensive pathway to pursue, given the extraordinarily high points that have become the norm in express entry, like exceeding 500 many, many times for this. So with that being said, the other question is office location, opening hours. So we're in Midtown Toronto at Eglinton and Don Mills. And the office hours are generally 9:30 to 5. In fact, I can maybe I can just get the booking link here. Maybe book an appointment. So that's the goes directly to the website booking link. So you can just do that online, right? Usually works for 80% of people, unless your internet signal is not good, then you'll get errors or something. So I'm told for this. And then I see sort of a follow-up to the policy-based Sudan question, which is, let's see here. So the idea is does the durable solution concern of the immigration department, does that affect the policy-based application? Going on the premise, which I recall, is that the policy is based on temporary status in Canada and having an anchor relative. So that amount of scrutiny about the possible durable solution should not really be there, because they're not contemplating permanent residency in Canada. So that should not necessarily be a determining factor in that temporary policy-based pathway for temporary residence for Sudanese nationals. With that in mind, we're...
Sorry to recap. It's not temporary policy. It's an permanent residency.
Okay, so if it's permanent, then yes, that could be an issue. So you have to be cognizant of that and then anticipate the officer's concerns by looking at the nature of the person's status in the third country that they're residing in, get some documentation about the nature of that status and what does that actually confer on a medium-term or long-term basis. If it does not confer very much, then it's good to convey that to the immigration department. Otherwise, because it seems to relate to a PR application where the stakes are higher, then it sounds like it could be refused on the basis that there is a durable solution in a country outside of the country of persecution for this. So,
Sorry again.
Mm-hmm.
He returned back to Sudan.
Mm-hmm. Okay, so this is, if it's the person returned to Sudan, and if this is, I should clarify, I mean, what category was the PR application under?
I think the public policy goes under humanitarian and compassion ground. It doesn't specify, but it states that. Okay,
so that is a pretty obscure policy. They truncated it in 2012. But I guess a sort of a miniature version of that still persists even now. So for this, one thing to review is that, does that humanitarian category have as its basic elements similar qualifications to the Convention refugee grounds, or is it just simply based on other factors? If it is based on the Convention refugee grounds, then the durable solution issue could be of some concern. So you'd want to make sure that the category that this permanent resident application came under actually is not synonymous with the Convention refugee grounds. Otherwise,
it's not. It's about just a Sudanese citizen affected by war.
Okay, so then in that case, the policy sounds like it's accommodating for the fact that some Sudanese people simply can't necessarily escape. So that would be outside of the normal refugee type of requirements, where you have to be outside of the country of persecution by necessity. With that in mind, though, I don't have the policy in front of me, but it sounds like the durable solution probably is not going to be something to be confronted in that application. But again, I mean, you want to make sure that that policy, because these policies are sometimes time sensitive and sometimes refer to other aspects of the act or regulations, that you want to be certain about that. So with that in mind, we still have 10 minutes. So I want to make sure that we have any other questions posed If not, then the idea would be that you can, if the question is more, more complicated, then it might necessitate a consultation with our office. On the other hand, the other concern that we have oftentimes is there are, and this concern arises sometimes in online with foreign languages, where people in a foreign language will talk about Canadian immigration policy, and it will be completely wrong. And I've had that occur. So I've seen people say, well, there's this policy for a work permit, and all you have to do is send your resume. And I've seen that type of sort of fake news look very impressive, almost in the form of a newscast, as breaking news. So in this sort of deluge of information that we get, it's a bit difficult to think critically about it, especially if the stakes are personally high for you and you really want the opportunity to work in Canada. So this could lead to a lot of vulnerable people being subject to losing a lot of money by being misled. We see this sometimes with people saying, oh, here's this email. It looks like it's a job offer. Can you look at it? And it looks like a doctored work permit. In other words, a work permit that's been altered, which is completely false. And then we, as a courtesy, we just say it's false and you should get legal advice. So these are sort of the extreme examples of misinformation. The other ones are looking at the IRCC website, and it's not really designed for navigating the policies which impinge upon many of these applications. The policies are available online, but they're designed for review by the officer, and as a courtesy, they put them online so that the public can see them, because that's an aspect of transparency that the government has. And sometimes these policies are not apparent when you fill out an application, because there's a completely different section about downloading forms, and they don't cite the policies. They just ask you the questions. So it's another danger you have to be aware of, that, for example, the PGWP policy, you could look for it. And if you read that, plus you also read the requirements for being actively engaged in studies, then you can have a firm grasp of what are the potential pain points for the issuance of a PGWP, but those necessitate referring to those two aforementioned policies, which are not in the application form. So something to keep in mind. I see another question here. It said, could you briefly explain how the PEI immigration program works? I think I had a client. Let me see if I can look it up. Okay, so for I see the sort of fundamental. I don't know if I can find that particular case we did, and it might be a bit too old, but a lot the fundamental. If we talk about the student-based one, right? So a lot of this requires a job offer. So the big sort of draw that these smaller provinces have, and what sort of constitutes a test of you, is that did you study in that in a university in that province, and did you work for at least 6 months in that province? The reason that is prized quite highly in the smaller provinces are because those are indicia of signs that you will remain in Prince Edward Island if you've done those two things. That's why oftentimes, I believe PEI, I think Alberta, they have these programs where you, unlike the federal express entry, you don't need 12 months, you only need 6 months, but you still need a job offer for these smaller based programs. And So it's sort of layered on top of the regular PGWP. And in rare cases, they have these jobs for lower skilled tier level 4, which is, like meat processing or fish processing. Sometimes there's a pathway for that as well, which is strictly job offer based. And then the other requirement is typically showing enough settlement funds. Unless it's a job offer, then you may not really need those, right? Aside from that, there's the the entrepreneur program for PEI, and it's similar to what I said, $600,000 net worth. Basic English has evidenced in a test, this sort of thing. And then all this goes into the PEI's version of their kind of provincial mini express entry portal that you register with the province. And then it goes through those sets of assessments. Either the would-be employer, that you have a job offer with PEI is registered with the province. And that's an essential component for that kind of set of immigration. So the sort of lens to look at that is that it's typically job offer based for the most part, except for what I mentioned about targeted draws, where if you just happen to have experience, then a certain province might say, oh, we like this. This person has a data analytics or something, a STEM job or healthcare, this sort of thing. So with that in mind, I don't know, we have a few minutes left. If we see anything else, if not, I just want you to be aware, because I think I was touching upon this this danger about the need to be aware if there's a program that's too good to be true, because in some instances there's a potential for exploitation and false hope being laid out for not very good purposes. So something to keep in mind as well for this. In the future, if you're in Canada, then hopefully there will be some attenuation of these high amount of points that are required for the express entry system, which I think is a function of too many candidates in the express entry pool, which is why the required points are exceeding 500 for this. Another point to keep in mind is that the points for the labor market impact assessment to benefit the permanent residency apparently will be canceled in the spring. So that means the pathway, if you're considering supporting your permanent residency by an LMIA now, don't bother, because an LMIA could take 4 weeks of advertising and perhaps 4 weeks of assessment by Service Canada. And then the benefit may only be that you can work in Canada rather than having additional points to buttress your express entry profile. So that's sort of a recent announcement from December 2024, which I think affects a lot of the people who are asking questions about PGWPs, which is, of course, the foundation for permanent residency in Canada. So with that sort of general process in mind, I think we're pretty well at time, so I can give you back 30-odd seconds of your time. Thank you so much for joining me today. I hope this had some utility for you. And if you have a more personal involved question, feel free to reach out to us. The main website is www.chaudharylaw.com, and enjoy the rest of this cold evening, assuming you're in Canada. Thanks. Bye-bye.